Welcome, ladies and gentlemen. For those of you who may not know me, I'm Michael Scharf, the co-dean of Case Western Reserve University School of Law, and it is my great pleasure to kick things off this morning, which is actually this afternoon. That's how my day's been going. But we are in for a real thrill this afternoon. This law school, you know, has had a long history of bringing in very distinguished professors and experts in international law to speak to our students. And we've had a number of the top people from South Africa join us. And again, today we have another amazing South African. Just to let you know, in the past, we've had Richard Goldstone, the former prosecutor from the Yugoslavia and Rwanda Tribunal, who was a constitutional judge from the South Africa court and also a member of the commission that helped lead to the dismantlement of apartheid. We had Albie Sachs here, one of the best human rights advocates in the world who played a huge role in the dismantling of apartheid. And this school has a really, really wonderful international law program with great international law professors. And just looking around, I see my colleagues Jevo Shabalala and Tim Webster, and we have 24 other people that are working and publishing in the area of international law. We also have people that have been working in the area of civil rights, which is relevant to this, and I see my colleague Rakaya Yerby here. I hope I'm not missing any more of my colleagues who are in the room. I see many of my students, but it is my great pleasure to introduce Tim Webster, who is going to introduce Professor Pierre de Vos, and he can tell you the story about how he got his name, which means the fox in Dutch. But without further ado, here's Tim. Thank you all.
Thank you. Well, thank you, Dean Scharf, for taking time out of your busy day to be with us today. I'm going to hand it over to Professor de Vos in a minute, but I wanted first to introduce him and also tell you guys about some of our upcoming events in international law. Dean Scharf has told you how important international law is to this school, and I will just add a couple of dates for you guys to be aware of. On February 17th, the Special Rapporteur for Toxic Wastes, the UN Special Rapporteur for Human Rights and Toxic Waste will be speaking here about the human rights implications of toxic waste. That person was invited by Professor Shabalala. That's Wednesday, February 17th. Later that week, on February 19th, we have a conference on international arbitration featuring some of the world's leading arbitrators, as well as people from the International Chamber of Commerce, who will be here talking about those issues. In March, we have Aaron Tapper, who will be talking about Indigenous rights and the apology to Australians' Indigenous populations. That's on March 15th. And then, as far as I know, this is going forward, we will have Prince Zaid, who is the UN High Commissioner for Human Rights, coming on Tax Day on April 15th. So that'll be obviously a very interesting lecture and a high point for us later this semester. Today, though, we are really privileged to have Professor Pierre de Vos from the University of Cape Town come and talk to us about the right to be different. Professor de Vos, as Dean Scharf has alluded to, is really a foundational figure in the LGBTI movement in South Africa. He has written, dozens of articles about it. He is quoted in national and international media through his own blog and through interviews with newspapers. He's been at the University of Cape Town for 7 or 8 years now. Before that, he taught at the University of Western Cape, also in South Africa. And one feature or one reflection of Professor de Vos's stature is that not only was he quoted in the Fourie decisions, of the Fourie decision, like Obergefell in this country, legalized same-sex marriage, and South Africa was, as you might imagine, a little bit ahead of the United States in this regard. They passed that decision in 2006. And if you read that decision, not only will you see Professor de Vos's scholarship cited repeatedly, he's so good that his jokes were cited as well. So, being cited by the Supreme Court is a big deal, but when they cite your jokes, you've made it to a whole new level of academic stature. And that's one that I think we're lucky to have someone of Professor de Vos's stature coming here and talk to us today. So, without further ado, I will ask Professor de Vos to come to the stage and to help us understand the right to be different in South Africa. Thank you. Thank you, Pierre.
Very much, Tim. And now I feel very pressurized to make jokes, which will be a little bit difficult to do, because if people expect you to be funny, that's usually when you're really not going to be funny. Ask any stand-up comedian. So, thank you very much for having me and for inviting me to speak here. It's a great honor to be here. And I want to speak today a little bit about the South African experience, but I will contextualize it, or try to contextualize it a bit more broadly. But I want to start by telling you just a small story. The day was the 26th of April 1994, and my then boyfriend and I went for dinner, and then we walked down in Cape Town. I stay in Cape Town. We walked down to the Parliament building. And in front of Parliament, there's a big flagpole. And at 12 o'clock, midnight, the old South African flag, the flag of apartheid South Africa, was lowered, and the new flag representing the new democracy was hoisted. And we stood there, and as we waited for the seconds to come to 12 o'clock, there was a huge group of people, and we were all shouting, down, 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 with the old flag. And then the new flag came up, and we all burst into tears. Because the moment, you see, I'm getting tears in my eyes telling the story, because it was such a profoundly important moment. Why? For many different reasons, of course, because finally we were democracy, and we're living in a democracy. And if you have grown up in an authoritarian system, a race-based authoritarian system, and suddenly you live in a democracy, it is quite a nice feeling to feel. Most of you probably will not feel that in your life, if I can say so. But for me personally, there was something else that made this a profoundly important and moving experience. And that is that at 12 o'clock, when that flag was raised, the new constitution came into effect. And then that constitution contained a section, it was then section 8, it's now section 9, that was probably the most powerful equality, non-discrimination provision of any constitution at that time in the whole world. And I'm going to read you the section. You can see that it's quite different from the kind of equality language that you find in the US Constitution. And what section 9.3 of the South African Constitution say is that the state may not unfairly discriminate, directly or indirectly, so it's not only direct discrimination that's prohibited, it's also indirect discrimination, against anyone on one or more grounds. So you can be discriminated against on more than one ground. The whole notion of intersectionality is captured in the section. And then it goes on to say that those grounds include, of course, race, gender, sex, pregnancy, marital status, ethnic or social origin, color, age, disability, religion, conscience, belief, culture, language, birth, and, for me personally, rather important, sexual orientation. And South Africa at that moment became the first country in the world who explicitly, in its constitutional text, included a provision that prohibited discrimination on the basis of sexual orientation. And of course, that if you go lesbian, it is quite an affirming thing to think that suddenly the Constitution outlaws unfair discrimination. But as we all know, texts are one thing. How those texts are going to be interpreted is another thing. And it wasn't clear exactly how a Constitutional Court of South Africa. A new Constitutional Court was created at the same time in 1994, how it would actually interpret such a section. On paper, it was very powerful, but who knows how judges, some of them who were educated in the apartheid era in a very formalistic legal system, how would they actually interpret the section? And the problem is extra problematic because we know that equality is quite a difficult concept to come to terms with. Why do we have equality and non-discrimination provisions in a constitution or international treaty or whatever? You can either have a relatively narrow conception of what equality means. I think that is closer to how the US Supreme Court at the moment conceive of equality as being necessary to recognize that despite any perceived or real differences between people, people should generally be treated in more or less the same manner, because that is one way of recognizing people's inherent dignity. So that is one kind of philosophical way of dealing with equality. But I would say that that is a relatively impoverished notion of equality. So I'm being a little bit naughty and critical of the US Supreme Court, and I think that the idea that equality and non-discrimination is really about whether you categorize people or not, and then decide whether that categorization should be dealt with in terms of strict scrutiny or intermediate scrutiny or rational basis, is a very old-fashioned, and for a South African person knowing with some knowledge of the South African constitutional jurisprudence, rather quaint, actually. There are other ways of dealing with equality and conceptualizing equality and non-discrimination. Ways that are more concerned with substantive ideas of equality, that moves away from the idea that equality is about equal treatment of people regardless of any difference, perceived or real, that they might have, and going further and perhaps recognizing that firstly, in a country where there has been a history of discrimination against certain groups, that the effects of that discrimination doesn't just disappear like mist in the morning sun. And so there is a need for, there might be a need for some redress. So in the South African Constitution in section 9.2 actually explicitly state that redress measures, affirmative action measures you would call it, is not an exception to the general notion of equal treatment. It is a requirement for the achievement of a substantive a form of equality in the long term. So this view of equality is really far more, in a conceptual sense, far more focused on how individuals and how rules and practices and principles and kinds of knowledge make it more difficult for some people to actually make real and meaningful life choices about who they are, how they want to live, than it does for others. And that there's always a hierarchy. There's always a hierarchy in which one group is privileged and another group is less privileged: white, black, gay, straight, women, men, women, able-bodied, disabled, and so forth. And that has to be taken into account. The power relations in society has to be taken into account when we deal with equality. And that second, more in line with the second view of equality, is the direction that the South African Constitutional Court went, borrowing, I have to say, a little bit from the Canadian Supreme Court. I'm not sure how many of you study the Canadian Supreme Court jurisprudence, but the Canadian judges are actually quite progressive, relatively progressive compared to some of the judges on the UN Supreme Court. They're basically radical. And for that reason, the South African Constitution Court borrowed from that and said, well, what the equality provision really should be about is about a kind of a rich idea of dignity. The idea that everybody has an inherent dignity, and that means that one should try and move towards a system in which people have the ability to make actual, real, and meaningful life choices about who they are, how they want to live, regardless of their economic status, their identity categories, and so forth. And he did so specifically in the first judgment of the Constitutional Court dealing with sexual orientation discrimination, the judgment that declared unconstitutional and invalid the criminal law provisions against sodomy. It did so by focusing, Justice Sachs writing concurring opinion and saying this, focusing on the idea of difference. And in that judgment, Justice Sachs, who's a very interesting, he was for 15 years on the Constitutional Court, a very interesting judge. I always tell the story of, in that sodomy judgment, how I think he's probably the only judge in the history of any court anywhere in the law, in anywhere in the world, who started judgment by saying, well, this judgment is only tangentially about who penetrates whom where. My students always get a little bit twittery when I quote that section, because judges are not supposed to mention like the ins and outs of sex in the first sentence of their judgment. But what he also said, he said that equality it's very easy to say that people should enjoy equality rights and shouldn't be discriminated against if they exactly like you are. It's far more difficult to conceptualize of equality when people are not like you, when they are different from you, especially if you are a member of the dominant, powerful group in society, or the group who's economically, culturally, socially dominant. Then it's far more difficult to actually recognize the full humanity of those who are not like you. And for that reason, he said, one can really reconceptualize the right to equality as the right to be different. So that equality is not a promise that you get that you will be treated the same as everybody else as long as you pretend to be like they are. Equality is something that you are guaranteed because you have an inherent dignity regardless of whether you are different from everybody else. And so it's for that reason that the Constitutional Court then developed this idea of a different idea of equality in the jurisprudence, which it applied in the same-sex marriage case, which finally in 1995 led it to find that preventing same-sex couples from marrying, that it was discriminatory and it infringed on Section 9 of the South African Constitution. And how the Constitutional Court in South Africa tried to operationalize that, how it tries to capture that idea of substantive equalities by saying, well, in each case you're going to make an assessment and you're going to ask whether the inherent dignity of a person is being affronted by, firstly, taking cognizance of the position of that person and the group that they belong to in society. So it's going to be much easier to show and convince the court that there is discrimination, infringing your constitutional rights, if you belong to a group that is marginalized, vulnerable, has been discriminated against in the past. It will be more difficult to show that you've been legally the victim of discrimination if you're part of the dominant group. If you happen to be a white heterosexual man, for example. I only tick 2 of the 3 boxes, so it's fine for me. And then the court said, on the other hand, what you're going to look at is you're going to look at why is it that the law makes this distinction? Why is there this distinction being made? What is the purpose of the distinction? Is it a salutary reason? Is there a pressing, important reason why the distinction is being made? And you're going to put that on the scales as well. So, for example, if you make a distinction between able-bodied and not able-bodied people by putting a rule in place that says you have to have a certain amount of eyesight before you can get a driver's license, that's discrimination on the basis of disability, but there's a very good reason for this. You don't want somebody who's blind to be able to drive. And so you put those things on the scale, and then you decide, is there unfair discrimination in this case? And the court explicitly used the term unfair discrimination. It says there are many forms of discrimination. When you make a distinction, say for example, you impose an affirmative action measure to address the effects of past or ongoing discrimination in society, then that is probably going to be a kind of fair discrimination, or not really discrimination in the legal sense at all, because that is what you're going to need to get to the end result. And so, given that framework, it was therefore not at all surprising that when the Constitutional Court had to decide eventually in 1995 whether the law prohibiting marriage against for people of the same sex, when it had to decide whether that was infringing on people's constitutional rights, it found that it was indeed unfair discrimination. And it did so by first asking, so what is the effect that this will have on the group that is being excluded? What is the impact of this on the group that is being excluded? Is it actually affecting their human dignity, given their position in society as a vulnerable group, a group that has always been the subject of vilification and bigotry and violence and so forth? And then secondly, it asks, so is there any purpose that is being served by actually having a ban on same-sex marriage? Now, interestingly, on the first question, the court said the reason why the impact on same-sex couples not being able to get married is extremely egregious and problematic is because there are actually two issues and two aspects, or two ways in which you are being affected in a negative way if you are denied the right to get married to the person that you love. One is the purely legal thing. You are being denied access to exactly the same kinds of rights that other couples would have when they get married. You know, rights about inheritance. In the US, it will probably be you can file joint taxes, property rights, all those kind of things. But the court went on and said, well, that is just one aspect or one part of the negative impact that the denial of same-sex marriage would have on same-sex couples. The other part is the intangible aspect, the idea that marriage bestows on you a certain kind of status. And Judge Sachs, in his inimitable way, actually says there, well, because when you get married, of course, you send out invitations, and then there's a big event, usually if you have enough money to pay for it, and then there's a celebration, and you take pictures, and then for the rest of your life you have that picture on the mantelpiece. Actually, later on, when Parliament had to discuss how to fix the marriage law, and I was one of the people who went to Parliament to actually speak to them and to explain to them what is required, the chairperson of the parliamentary committee, Congress committee, asked me, so he was a bit homophobic, so he asked me, so why do you people want to get married? So I told him, quoting Judge Sachs, who said, there's this intangible aspect. And I said, well, you don't know my mother. Like every mother, she wants that picture on the mantelpiece of her son getting married. And if you're going to deny her that, you're going to be in very big trouble. So in the end, the Parliament adhered to the Constitutional Court judgment. I don't know if that had anything to do with it. So for me, that's quite important. It's the idea that when you think about equality and you think about affirming people's rights, it's sometimes about more than just about legal rights. It is about the symbolic aspect of being denied equal treatment and equal respect. In the same way that with the South African Constitutional Court, when it dealt with the sodomy case, said, well, even though in South Africa, sodomy, same-sex sodomy, consensual same-sex sodomy is not really prosecuted anymore. It's like also possession of small amounts of cannabis are not prosecuted. You don't all now rush to come and visit us in South Africa. But the court said it's not just about that you're going to actually be prosecuted. It's about the symbolic effect the signal that it sends. It says that you are not actually you do not count as much as other people in society, and that is important. So that's the first aspect of the balancing. The second question then was, but isn't there perhaps a good reason for having a ban on same-sex marriage? And there two questions specifically arose. The first issue that was that opponents of the legalization of same-sex marriage raised was that that marriage was really, by definition, about procreation. I think most of you might have heard that argument already. And the idea that marriage could not be extended to same-sex couples because same-sex couples generally do not procreate. That is, of course, factually not correct, but okay. So the Judge Sachs answered this question and said, no, this is clearly untrue. Because marriage cannot be about procreation, because many people get married who are not capable. Different sex couples get married who are incapable of procreating. Or many different sex couples get married and have already decided that they're not going to have any children. So they are not prohibited from getting married. So this cannot possibly be any reason for the marriage to be limited to different sex couples. The second argument, which you might also be a little bit familiar with, I'm thinking Kim Davis, is that marriage is by its very definition a religious institution. And that because it's supposedly a religious institution, if you're going to open up the institution of marriage to all couples, then you're going to infringe on the rights of religious people, or those religious people who actually believe that same-sex marriage is a sin or that there's something wrong with it. The court also, of course, rejected this argument and said, well, this is factually not correct, because you are not going to force any religious person to enter into a same-sex marriage. If your God, whom you have prayed to, has told you that this is not a good idea, then you can stay celibate, or you can marry somebody of the opposite sex, or whatever the case might be. The judge didn't say that, but I'm just making that up. Moreover, the court said that if you're living in a constitutional democracy in which both the right to equality and freedom of religion is being protected, then there has to be an accommodation between the secular and the sacred. And in the public space, the sacred cannot trump the secular concerns for other people's human dignity. And so, while individual religious denomination or church can decide for itself whether it wants to solemnize marriages of same-sex couples, and they should be allowed that, and they should have the right, the court and the state cannot prescribe to a religious group whose marriages they need to recognize. At the same time, the religious groups cannot demand that a certain group in society should be discriminated against, because then it will not be religious freedom, then it will be religious tyranny. Interestingly enough, last year, 10 years after the judgment was handed down, the biggest Afrikaans church in South Africa, the church that was often during the apartheid years referred to as the apartheid government in prayer, it actually, at its national synod, it adopted a resolution to say that it would actually recognize same-sex marriages and have such marriages solemnized. And it became the first church in South Africa to openly say, well, as a matter of religious faith, we believe that people are sacred and that people should be protected. And so our faith demands of us to recognize the full humanity of people who are not whose sexual orientation is not heterosexual in nature, and for that reason they recognize it, which is it's quite a radical thing to do. It's like it is. If you were familiar, if you had grown up in apartheid South Africa like me, in the Dutch Reformed Church, and having had to go every Sunday to the sermon where the dominee, the minister from the church, actually spoke about how apartheid and racial segregation was the word and the requirement of God. 20 years later, to have that same church say that same-sex marriage is actually something that God requires us to recognize, it's quite a profound difference in behavior. And so for those reasons, the court declared the Marriage Act, which limited marriage to different-sex couples, unconstitutional. But normally what the court would do in such a case, it would just say, well, the Marriage Act is unconstitutional, and the South African court is quite radical in the remedies that it offers, so it has this idea of reading in. So when there is a law, and the law is under-inclusive, and if one or two words could be added to that law to make the law compliant with the Constitution, the Constitutional Court often just reads those words into the law. And it says, well, if the legislature doesn't like it, it can always change the law and amend it again. But this is how we're going to fix it, so that there is an immediate remedy for the litigants who came in front of us, who came to the court. In this particular case, the court didn't do that. The court actually said, yes, this is unconstitutional, yes, it has to be fixed, but we are going to ask the legislature, Parliament, in your terminology, Congress, to fix this situation. And the court said you have to fix it. You have to fix it in a way that is going to address both the fact that the denial of marriage rights denies same-sex couples legal rights, and you have to fix the problem that it denies people that equal status, the intangible things that come with marriage. And, said the court, invoking a specific judgment of the Supreme Court during the apartheid years, where a lawyer challenged the practice that was prevalent until the 1970s in South Africa of providing a separate desk depending on which race you are. So if you're a lawyer, if you're a black lawyer, you've got one desk. If you're a white lawyer, you've got another desk. And this lawyer, who used to work for the law firm of Mandela and Tambo, yes, that Mandela, he challenged this in the court. And at that stage, the court said, no, there's no problem here, because the two desks are exactly the same size. It is separate but equal, and therefore there's no problem with this. The Constitutional Court invoked that example and said, clearly that will not be acceptable in a democratic South Africa with this kind of Bill of Rights and equality provision in the Constitution. So you cannot create a separate but equal regime. What the Parliament in the end did is a very strange compromise. Parliament left the original Marriage Act intact, and so that Marriage Act only applies to heterosexual couples. But it then passed a second law, Civil Union Act, which is basically a second Marriage Act. And that Marriage Act is different from the first act in three ways. Firstly, the second Marriage Act, the Civil Union Act, allows not only different-sex couples from getting married, but also same-sex couples. It allows both different-sex couples and same-sex couples to decide whether they want to call their marriage a marriage or whether they want to call it a civil partnership. But legally, it would be exactly the same as a marriage. But you can call it a civil partnership. So, for example, if you think that marriage as an institution is a patriarchal institution by its very nature, I always joke and say, I would love to get married, I just don't want to be married. I would love the party, but I wouldn't like, because that idea of being a spouse is a bit weird for me, but okay. So if you're one of those people, you can still get all the legal rights, but you can tick the box and say civil partnership. But you can also tick the box that says marriage. And the third difference, the one that's probably unconstitutional, but we didn't manage to get the parliament to change their view on that, is that if you get married in terms of the Second Marriage Act and you are a state official who's going to issue what you would call a marriage license, and you are allowed to refuse to do so because of your religious beliefs. So that Kim Davis exception is in the South African law. I was at a workshop the other day in which finally we are starting to think about how we can challenge that, because I think if we challenge it, it's probably going to be found to be unconstitutional. And so Parliament passed the legislation, and in doing so, the day it passed the legislation, South African Parliament works a little bit different than the US Congress. We have a very strict party discipline, so political parties vote according to how they are instructed to vote. All the members are basically told you have to vote this way. So there was no suspense that Parliament would pass it, because the majority party, the ANC, had already decided going to support this. But the surprising thing, and for me very moving, I actually watched the speeches, and the very moving thing was that the person from the governing party who gave the most powerful and the keynote speech, so to speak, in favor of passing the legislation, was at the time the Minister of Defense. So, he was like the most macho person in the room, basically. And he gave extremely moving speech in which he referred to this idea of how in a diverse society especially we have to recognize difference and diversity, and how this piece of legislation is actually affirming a section of the South African population's human dignity and their humanity, the very thing that apartheid robbed many people of in many different ways. And I was quite intrigued that he would give this speech that was clearly heartfelt. I mean, I didn't realize that, he didn't strike me as a guy who was like a gay rights activist. And then only afterwards did I realize, but in the 1980s, during the struggle for apartheid, he was actually a treason trialist with Simon Colley, who was the most famous South African gay rights activist. But he was also, of course, an activist against apartheid. And so a group of people who were fighting the government, the apartheid government, were all arrested, and they were tried for treason. In the end, they were acquitted, but for 3 or so years, they were locked up together. And during that time, he came out to his fellow treason trialists, and he told them that, listen, I'm actually gay, and you have to accept me. And because of that personal interaction, I think, partly at least, the Minister of Defense at the time was so passionately in favor of this right to be different. And I think there's a lesson in there about how sometimes the law can change, a lot of the Constitution can change or help to change a lot of laws. It might be able to change certain attitudes, but one mustn't underestimate the importance and the power of personal relationships and of making alliances with people who are involved in different struggles when you want to actually change the world, and using those alliances along with some of the legal text in South Africa, easily the Section 9 of the Constitution. Thank you very much.
So we are going to have a reception in about 5:25 or 5:30, but I did want to open up the floor to people who might have questions or comments, particularly in light of what's been going on in the United States over same-sex marriage and gay rights. They wanted to ask Professor de Vos about what's been going on in South Africa, about lessons that the U.S. might want to apply in South Africa, or other questions you guys may have. And if no one will, then I'll exercise my or Kate, go ahead. I think you need to have it. We're going live on the web with this, so we'd ask you to use the microphone so that folks at home playing Jeopardy can also
All right. Well, first off, thank you for a very, very interesting lecture. My main question is just, I think that there are a lot of lessons that we in the United States can take from the legal developments in South Africa. And you spoke a lot about the social progress that's been made both in the parliament and also within civil society institutions, like the church that you mentioned. I was just wondering if you could elaborate a bit more on how civil society institutions in South Africa have responded to more progressive non-discrimination initiatives. And further, what do you see going forward as the major challenges within civil society and any potential solutions that you see in the future as well?
Yes, you know, it's quite strange because in if you in terms of the constitutional protection, but also in terms of legislation, uh, the protection is extremely powerful. So there's legislation, for example, that prohibits discrimination on any ground, any of those 16 grounds I mentioned in the employment context. There's legislation that prohibits discrimination on any ground, those 16 grounds, of any company or any private institution, any say restaurant or bar or whatever the case might be. My partner and I were actually the first ones to use that piece of legislation because he was not allowed into a bar because of some racial discrimination. The law is there. The law itself and passing good legislation doesn't change people's attitudes. So there's still a gap. It's different, you know, if you're a white middle-class person living in Cape Town, you know, it's like being in New York or San Francisco. But if you, in some other places, if you are less empowered in terms of economic status and so on, and race and so on, you might encounter a lot of prejudice still. And so what civil society groups have done, NGOs and so on, is to try and work on that. There's a lot of kind of initiatives, education initiatives, a lot of kind of activism that is not necessarily aimed at legal change, because the legal change has happened, apart maybe from hate crimes, but that is now in the pipeline. So a lot of the emphasis is on how do we change people's hearts and minds so that it's a little bit closer to the kind of values in the Constitution. And so that's a big challenge because, you know, bigotry doesn't just evaporate because you happen to have a black president. I'm not mentioning any country. And so it's very difficult to change people's minds. I think it's very hard for people who are maybe fearful or invested in a certain way of being in the world to realize it's actually quite liberating not to fear and to hate other people. So there's a lot of work to be done also within the state, within the police service, within among, say, teachers. Because I think that especially in rural areas, teachers are still often quite bigoted in terms of race, in gender, sexual orientation, disability, and so on. And so there's a lot of work that we try to do with that. To what extent it's successful, I don't know, because I'm not a social scientist who's gone out and done all the research about attitudes and how it has changed. But I think there has been quite a shift in people's attitudes on the issue of sexual orientation. I think we're still struggling with race and to confront the full enormity of 350 years of colonialism and apartheid. It's not something that's going to go away. It's like a specter, it's a ghost that's hanging over our heads that we are fighting with every day, I think. Yeah.
Thank you. I'm sorry, I did miss part of your talk, but I would say here in the U.S., one of the maybe the most one of the most contested, sort of divisive issues right now is something you mentioned almost in passing, which is the sort of conflict between religious freedom and gay rights, or in general, sort of anti-discrimination rights, maybe. And so you mentioned that you thought that the carve-out in your legislation in South Africa would be held unconstitutional if it was challenged. And I was just wondering if you could say a little bit more maybe about the legal reasons why, and or about sort of whether that conflict has the same cultural salience that it has right now in the U.S.
Yes, firstly, maybe the South African Constitutional Court has dealt with only a few cases dealing with religious freedom. And in some of them, where there was a clash between not a church, not a religious institution's right, for example, to appoint only men as priests, like the Catholic Church, not that kind of thing. But when there was a clash between people's personal religious beliefs and general standards that protects rights, the rights have trumped the religious freedom. For example, there was it sounds a little bit primitive, but Parliament after '94 outlawed corporal punishment in schools, because before, when I was at school, corporal punishment was administered very enthusiastically and vigorously. So a little, especially in the math class, it was terrible. And so it outlawed it, and then Christian schools private schools that have a specifically religious character said, well, there are all these Bible verses, if you spare the rod, you spoil the child. We are toned by our religious beliefs. We are impelled to actually administer corporal punishment. And again, Justice Sachs, the same guy who wrote the same-sex marriage judgment, said, well, you cannot just have religious exemptions for everything, because that will create chaos. There are certain basic norms that have to be applied, especially in the non-institutional context of a church. And so the court said you cannot get an exemption to this. In the same way that in another time the court also said that the law that prohibits the possession and use of cannabis, you cannot make an exception only for Rastafarians who, as part of their religious beliefs, believe that you have to smoke the holy weed, the holy herb. Although the second case, maybe because it was a vulnerable group and a minority group, it was 6 votes to 5 votes, or 5 to 4 votes. So it was quite close. But nevertheless, so far, whenever there was that kind of clash, the court has come out against the religious group. My sister and I have just taken unsuccessfully a case to the Constitutional Court where a minister of the Methodist Church was fired from a job when she announced to the congregation that she married her girlfriend. And the argument that we made is, well, your religious doctrine doesn't actually explicitly say that same-sex marriage is against God's will. It's just a rule that you've always had because you're still praying about this, and until God has spoken to you, you cannot discriminate. But because the client had refused to first engage in arbitration, which was required by the contract between her and the church, the court, because this was they didn't know how to deal with this, they said, no, go for the arbitration first and then come back to us. So in 2 years, we'll see what the court says about that.
So Justice Sachs is not adverse to using international legal concepts when he writes opinions. And of course, Arthur Chaskelson did it beautifully in the death penalty decision in the South African Constitutional Court. How much, I've not read the opinion, how much of the opinion relies on foreign jurisdictions' legal theories to support it, or how much of it is grounded in just South African principles of democracy and human rights?
Well, you see, by the time the Constitutional Court handed down the marriage decision, it had already developed a rich jurisprudence both on equality law and on equality law as it applies in cases of sexual orientation discrimination. The judgment, there's quite a lot of footnotes in the judgment, but I think if you read it, most of the rhetorical and legal power of the judgment comes from it actually invoking its previous precedent. So there's like 3 pages of, we've decided this and this and this and this, and so, well, we can't really do anything else. This is all our precedent leads up to this point, so we're going to decide it on this matter. So unlike, say, the Indian, the Delhi High Court, which before it was overturned on appeal, but when they had to declare unconstitutional the penal code that criminalized same-sex sodomy, it quoted extensively from all over the world, South African Constitution and so on. Our court at that stage did not really quote as extensively from international cases. And in any case, the South African court is a bit reluctant to quote the US Supreme Court because it's a bit too conservative for it. It quotes the Germans and the Canadians, as I've said. Yeah.
Pierre, thanks for a really stimulating talk. I want to talk a little bit about the grace period that the Constitutional Court allowed the Parliament. And I'm wondering if that was, if it's common for the Constitutional Court to do that, say, take some time, get back to us, whether there was also a secondary audience of South African citizens saying, hey, get behind gay marriage or get behind same-sex marriage, this is the way it's going to be. And also I'm wondering, because I think in this country we had a similar kind of ruling with Brown v. Board of Education, which desegregated or purported to desegregate American schools and say, look, we understand this is a large social issue. We're not going to give you a year the way the Constitutional Court did, but with all deliberate speed, we'd like you to integrate your classroom. So I'm wondering if you could just comment on, if it's common in South Africa to give that kind of grace period, and also who the intended audience of that grace period might have been.
Yes, so the South African Constitution, once again, when you look at the powers granted to the court, those powers are very extensive. It says that whenever a court finds that a legal provision is unconstitutional, it has to declare it unconstitutional, but it can make any remedy that is just and equitable. And so the reading in, it has done that. Sometimes what it has done, it has said, and it has happened in several cases, especially where there is not an immediate need of the individual litigants before the court to say, well, this is a complicated issue. If we declare this whole law now invalid, it is going to create legal chaos, and then it suspends the order of invalidity for 6 months, 1 year, or 18 months. And it says, Parliament, you have 18 months or a year to fix the problem. If you don't fix it, and that's what the court also said in the Fourie judgment, then we are just going to assume that the words are read in, or that it is fixed in this particular manner. And so it has done that, and it does do it does do it in certain instances. In this case, it definitely did it, and Judge Sachs explicitly says so. It did it because it was afraid that if the court hands down a decision that immediately grants same-sex marriage, it would have less legitimacy in the eyes of the population. It will expose the court to criticism and threaten its institutional security. And so maybe if a parliament which is dominated by one party, the party who also is the party of liberation, so it has a certain amount of authority and respect that maybe political parties in the US don't enjoy anymore. If that happens, then it actually stands a chance of really changing people's hearts and minds. And so at the time when the judgment came out, many of us who know a bit of constitutional law said, they are not particularly consistent here, because in the other same-sex cases, in other cases dealing with sexual orientation discrimination, they immediately gave a remedy. Here they didn't. Why? Because of the judicial politics. And we were critical of this, but I have now later changed my mind about it, and I thought it was actually a very wise pragmatic decision on the part of the court, because I do think that the heat that the court might have experienced, and the attacks on the same-sex marriage was much diluted by the fact that it was actually finally brought to South Africa by the parliament and by the majority party, who then made all the beautiful speeches, as I have alluded to. Yeah.
I'm curious to know how the decision allowing same-sex marriage, marriage equality in South Africa, affected families. Are children of same-sex couples presumed to be children of both parties, even if assisted reproductive technology is used?
Yes. Well, before 2003, there was a specific piece of legislation in South Africa reflecting sort of the Calvinist religious attitudes of the apartheid government, that said that if you adopt a child, then you have if you cannot co-adopt a child unless you are married. So my sister and her partner, at the time, it was before same-sex marriage was legal in South Africa, they adopted children, and then she was a judge at the time in the High Court, and they challenged that law as unconstitutional, and they won. And so after that, the law was changed for same-sex couples, that you could jointly adopt. From 2006, the position is now as follows: if you're in a same-sex relationship, then both or one of the if you are the parent of the child, then you are the parent of the child legally. If not, you have to adopt. If you're not married, the parent will have to co-adopt if you're in a relationship that is not a marriage relationship, for you both to be the legal parents. But if you are married to your partner in a same-sex relationship, whether you now adopt or whether the child is produced in any other way, biologically, both the parents are exactly the legal parents of the child, as if you're a mother and father who make a baby. Yeah.
Maybe we have time for one more question.
Thank you, sir. I'm sitting here thinking, if there is any country now, just like 1994, South Africa, to make a new constitution, I still think it's very difficult for that country to put the same-sex term in the constitution. So I think, do you think it's really necessary to put the same-sex term in the constitution? Why we cannot put it term in the federal law and just ask the constitutional court to rule the case? Why do you think that's really necessary to do so?
Okay, you of course correct. About 4 years ago, Kenya they drafted a new constitution, and if you read the text of the Kenyan constitution, you will see many of the sections are almost word for word like the South African constitution. Maybe because my colleague was one of the legal advisors who helped with that, and they just borrowed. But the one remarkable difference is the equality clause is exactly the same wording, but that sexual orientation is not included, and then it was done on purpose. The reason why, politically, it's always better to have it in the constitution if you can get it in there, because it clarifies the matter and it helps maybe the legislature would otherwise would be a little bit worried because of public backlash. It helps them to nod them in the right direction. If you don't have it in there, you are really depending on the politicians, who depends on being elected, and therefore on the society as a whole to change. And that takes much longer, obviously. In the US, it so happens that over the last 10 or 15 years, there's been a huge change in attitudes. But the question is it not better to try and nudge the change along also, and that can never be the only tactic, but also with the use of constitutional provisions. But sometimes it won't be possible, and then you have to, of course, do it in other ways, and the harder work of actually changing people's hearts and minds to win the political battle. Because there is, as the South African case shows, I think there is always the danger, and the courts will always be aware of the danger, that they don't want to make a decision that is so far ahead of what people actually feel that that decision has no legal or moral authority in that particular society. So there's always difficult, this is a difficult strategic question that one must always ask oneself. Yeah.
Pierre, thank you again for really sticking Thank you. Well, again, thanks to all of you guys for coming. We will have a reception outside, and I would ask you to join us out there for some drinks and refreshment. Thank you.